Hello everyone, today I'll be sharing another legal story with you. So what happened on 27th August 2020 is that the Supreme Court was dealing with the case of Dogi Parthi Venkata Satishan and other versus Pille Durga Prasad and others. So the dispute in the case arose when the lease deed expires. So the respondent, that is Aditya Motors, which is a sole proprietorship, they refused to vacate despite the expiration of the lease deed, right? So in response, the landlord, they instituted a eviction proceedings in the name of Aditya Motors. So they instituted a eviction proceedings against whom? Against Aditya Motors. Okay, that is Aditya Motors as a defendant. Okay, later on what happened, they amended. So the plaintiff or landlord, they amended the plaint and they substituted the proprietor Prasad as the defendant. So in the originally the defendant was whom? The defendant was Aditya Motors. Okay, later on they amended the plaint and now the defendant is whom? The defendant is proprietor Prasad. Okay, so this prompted the defendant the whom? That is Prasad, okay, to seek the rejection of plaint under order 7 rule 11. So the proprietor, he seek Prasad, basically who is the defendant, he seek the rejection of plaint under order 7 rule 1, arguing that the since the substitution of Aditya Motors with the proprietor Prasad as the defendant, it extinguishes the cause of action. So the cause of action as extinguishes. Okay, the trial court dismisses the plea of the defendant. So trial court dismisses the plea of the defendant regarding the extinguishment of cause of action, since the firm, that is the proprietorship firm, has been substituted with the proprietor Prasad as the defendant. Okay, so because of which the cause of action is extinguished. So this plea was made by defendant and this plea was dismissed by the trial court. So trial court dismiss कर देता है. Later on High Court allowed this plea. So High Court allow कर देता है इस plea को, and stating that the suit ought to be maintained against the trade name. Suit जो होगा वो trade name के against ही maintainable होगा under order 30 rule 10 of CPC. Okay, this is what High Court said. They allowed the plea, stating that the suit is maintainable against the trade name under order 30 rule 10. Supreme Court said that firstly they set aside the decision of the High Court. So they set aside the decision of the High Court. Okay, stating that the suit originally was filed against the proprietorship firm, that is originally it was filed against Aditya Motors. Okay, and later it was to substitute proprietor's name in the place of a firm, right? Later the Aditya Motors was substituted with whom? That is proprietor Prasad, right? It was substituted. So the suit cannot be dismissed since proprietorship has no independent legal existence apart from the owner. So the this suit cannot be dismissed because the proprietorship has no independent legal existence. So the proprietorship has no independent legal existence apart from the owner. Okay, so the suit cannot be dismissed, and they basically rejected the plea of the defendant that was made in the front of High Court. So basically they set aside the decision of the High Court. Okay, they uses the use of word in order 30 rule 10 CPC only indicates that the proprietorship consent may be made a party. So as per order 30 rule 10, only proprietorship, that is the Aditya Motors, can be made a party. However, it does not mean that the proprietor itself, that is the proprietor Prasad itself, if made a party, would not be enough. So it does not mean that if we made the proprietor Prasad as the party, this would not be enough. Okay, later also they said that the proprietorship is to be defended by the proprietor only. Okay, because it is a sole proprietorship and it has to be defended by the proprietor only and not by anyone else. Okay, the High Court seems to have taken hyper-technical view. The High Court has taken technical view and not realizing that no prejudice is caused to, and the no prejudice is caused, and the cause of action accrued against the proprietor as he alone signed the lease deed. Since the lease deed was signed by the proprietor, the cause of action accrued against him, right, on behalf of the proprietorship also. So on behalf of proprietorship also, the cause of action will be accrued against whom? Against the proprietor. Okay, and the one more important thing is there is no involvement of any second or third party, right? So there is no involvement of any third party or second party, and because of which no interest has been prejudicially affected. So no interest has been prejudicially affected because there was no involvement of any other party. So the court said that the suit against the proprietor Prasad is also maintainable, despite the fact that the order 30 rule 10 said that the suit to be maintained against the trade name and not the proprietor. But no, there is nothing said about that the suit cannot be maintained against the sole proprietor, because he is the one only who is managing the proprietorship. Okay, so the suit against the proprietor is also maintainable. Okay, thank you so much.